of the afternoon docket. Case number 128612, Mark Crawford versus Spirit Aerosystems, Inc., and AIU Insurance Company. And parties, you can submit your appearances when you go to the podium. Do you want to keep this? Yeah, fine. I have lots of copies.
May it please the court, Jeff Cooper, attorney representing Mark Crawford, the claimant for the injured worker in this workers' compensation case. The claimant appeals from a board decision.
Mr. Cooper, can I interrupt you for a second?
Sure.
How much rebuttal time would you like?
2 minutes, please.
All right, thank you. 2 minutes will be granted. We're gonna, if you can just wait for a second, we're gonna get that clock going so you could start with 13. Thank you.
Thank you. Claimant appeals the board's finding that the claimant failed to meet its burden of proof that his repetitive trauma injury, December 1st, 2020 through January 22nd, 2021, was the prevailing factor in causing his cervical, spine, and shoulder injuries. Claimant requests that the court issue an order finding the board's denial of those benefits was not based on substantial competent evidence, and I'll go into more detail on that in a moment. We believe that credible evidence supports the finding that his work injury was the prevailing factor causing his injuries, his need for treatment, and resulting disability or impairment. Factually, the claimant began working for the respondent in February of 2014 as a sheet metal fabricator, which everybody agrees was a medium to very heavy job. Job requirements require him to lift 25-pound braces, 2 at a time. So he's lifting 50 pounds, and he has to flip those, install those. And during the course of installing and flipping those boards, starting in December, he developed severe neck pain, especially on the right side. I think it's important to note that the claimant worked this job for 6 years before the injury. He provided written documentation of no physical limitations when he was hired. In fact, he took and performed a pre-employment physical at the request of the employer for the heavy job, and passed that and worked that heavy job for 6 years until his problem started. Now, he did have some minor incidents of neck pain in the past. Record talks about an incident in 1999 while at Worlds of Fun. Didn't have any lasting problems from that. He fell on the ice in 2008. He was cleared after falling on the ice by Dr. Barrett. No restrictions, no impairment from that event. Next known record of any neck pain is 2016, after he goes to work at Boeing. And that was through Dr. Reichenberger, his primary care physician. Dr. Reichenberger, excuse me. So Dr. Pratt, who did a court-ordered IME, and I'll explain that in a moment, did indicate that Dr. Reichenberger in 2016 indicated the claimant at that time had left-sided neck pain and tingling in his left arm at that time. I'll submit that both the ALJ and the board erroneously said that in 2016 he had right-sided neck pain. There is no evidence of that, and we submit that that's an error. His complaints following the work-related injury were to the right side primarily at that time. There's no records of any right arm complaints from Dr. Reichenberger until January 15 of 2021. I submit that's important because Dr. Pratt ignored those records. There's no complaints of any right-sided neck pain, any right-sided arm tingling pain. The notes from Dr. Reichenberger notes a 4-week history of pain in the right side of his neck, shooting into his right arm, which he attributed to his work activities. There's no notes that are in the record of any complaints from 2016 until this injury of 2020. He was, again, working a heavy job, full-time, without any problems. Spirit denied the claim. We sent him to see Dr. Marati. Dr. Marati said the work injury was the prevailing factor. Insurance company sent him to Dr. Feverly. Dr. Feverly said work injury was not the prevailing factor, that smoking and his age were the problems. Based on that, the administrative law judge sent the claimant to see Dr. Terrence Pratt, a physiatrist in Kansas City, for a court-ordered IME. Dr. Pratt states he couldn't relate his cervical problems to work activities, and he said he had prior symptomatic involvement. I think it's important to note right here that if you read Dr. Pratt's report, there's no evidence that he had any indication that this gentleman was working a heavy job for 6 years before this event at work occurred. I think that shoots a hole in his opinion, and I think the board and the judge erroneously relied on his report when he didn't have the factual basis to make that determination.
And counsel, when you say event at work, am I correct that there wasn't like one precipitating event? There wasn't a fall or some incident that happened one day. It was a progressive, kind of repetitive.
Yeah, it's what we
injury
call in
over-
the practice a repetitive trauma injury, where
Okay.
you're doing your normal work activities and you start having pain. And that's what he testified about, and that's what all the records consist of. And I don't think the respondent's denying that he had a work-related event. They're just denying that it didn't cause the problems that he ultimately had surgery
They
to
characterized
correct.
it more as a flare-up of a
Yeah,
pre-existing.
yeah, they said it's
Yep.
just an aggravation of a pre-existing condition, which in Kansas is not a compensable event anymore. I again submit that for the right shoulder, there's no significant evidence of any pre-existing condition. Like I mentioned, Dr. Pratt never mentioned, was not aware that this gentleman was working a heavy job for 6 years without any significant problems. Never was taken off work until this event happened.
So the smoke and old age reasoning really doesn't fit then, does it, or does it?
Well, that's our position, that the board relied on his testimony when it wasn't based on all the evidence that should have been taken into consideration. If you take his testimony into consideration, which is not refuted by anybody, he worked there 6 years and nobody denies this was a heavy job, physical job that he did without any problems until started having problems in December. Dr. Pratt never even considered or mentioned any prior complaints being left, and pretty minor complaints. Here his problems are on the right side, doesn't even address that. But based on Dr. Pratt's opinion, the court denied any treatment, and the claimant sought treatment on its own with Dr. Dickerson, who most of you probably are familiar with, a neurosurgeon with a very high reputation here in Wichita. Dr. Dickerson performed surgery. He saw what condition was of this gentleman's neck, and he said that based on his findings from the surgery, that the work event was the prevailing factor resulting in the need for his hernia surgery and his resulting impairment and disability.
Now, counsel, let me step back a little bit. It's my understanding that yes, Dr. Dickerson, when performed the surgery, his findings found the surgery was necessary, but it's my understanding that the only connection between the condition and the employment and the only basis for Dr. Dickerson to make that connection was your client's subjective history to Dickerson, telling him they were connected. Is that true? Is there something else that he based
I think
that
that
on?
is essentially true. I mean, that's where Dr. Dixon got the information. But I asked Dr. Dixon, you can read his deposition, when he did the surgery, he saw what he thought were acute findings that were causally attributable to his work injury. He didn't say he did surgery on this guy because he had old age problems. He said he had herniated disc and that those discs were caused by the work events.
But he also didn't review any past medical records, correct?
Yeah, and that was a big point was made. What past medical records are relevant? That he had some minor pain before. Dr. Dickerson very clearly said, there's no way this guy could work for 6 years with the condition of his neck that I saw him on when I did the surgery. So you're correct. He did not have the prior records review. I didn't hire him as an expert. I took his deposition because my client had surgery by him, and I contend that based on the surgery, he is in the best position to tell the court what the cause of the problem is. It's our position that the court's reliance on Dr. Pratt is erroneous because he didn't have all the information he needed to make that determination. I think it's also not common sense. This gentleman couldn't work for 6 years and do the kind of job he did.
Can we go back to Dr. Dickerson? It's
Sure,
my
absolutely.
understanding that the Spirits Council, they cited some other testimony in their brief from Dr. Dickerson where he supposedly admitted that he saw degenerative changes and some recess narrowing in the MRI that would take years to develop, and agreed that those conditions could be asymptomatic. Do you have any disagreement with?
Oh, I think,
I mean, did he-
certainly I can't disagree with Dr. Dickerson. He's very well trained and an expert. I think all of us, when we get 65 or thereabouts, we probably have some degenerative problems. I can't dispute that this guy, he worked hard his whole life, he has degenerative problems. But Dr. Dickerson, I believe, very clearly said the reason he did the surgery and the reason he had to have the surgery was because of the work injury and the herniated discs that he operated on. We believe that if you look at all the evidence in the record, the reliance on Dr. Pratt is erroneous, is not based on competent medical and competent evidence, and should be not utilized by this court.
What's the problem with relying on Dr. Pratt's opinion? I mean, that the court appointed him, and it's my understanding that he did look at the past medical records to kind of come up with his analysis. What's your issue with the basis for his opinions?
The basis for his opinion is he didn't consider all the appropriate information to arrive at an opinion. He assumed he had old age-related problems, but he didn't look at his work history, didn't look at his lack of symptoms, working a heavy physical job for 6 years. I mean, he had some very minor problems, but look at Rickenbacker's records. Rickenbacker's talking about left-sided neck problems that are minor. You know, he sees him one time, basically, for each little episode. There's no ongoing treatment. There's no, complaints of ongoing pain and problems. And that's consistent with what Dr. Dickerson and consistent with what my client says, that he got along very well up until December when started having problems while flipping these trusses and braces and lifting the heavy weights. And he described the pain as different, much more severe than what he had ever had in the past. And that would be, I believe, consistent with Dr. Dickerson's testimony in the case. Looks like I'm about out of time. I think I've covered the main points. In conclusion, we just believe that the board's decision doesn't meet with the credible medical evidence and the factual evidence in this case. I would request a careful review of that. Thank you for your time today.
Thank you. You'll have your 3 minutes for rebuttal.
Thank you.
Hey, please the court, Vince Burnett on behalf of Spirit Aerosystems and its insurance carrier AIU. Also present is Pam Parker, who was on the briefing for all of the briefs that we filed. Clearly, it's a workers' compensation case. We have exhaustively briefed this case, not only to the judge with a submission brief outlining the evidence, also to the appeals board, and then obviously to this court. I want to start with the standard of review, and I'm sure you already know about it, but obviously I think it's important in this case because of what counsel for the claimant is asking the court to do is reweigh the evidence, reweigh the facts, reweigh the credibility determinations by the administrative law judge and the board, and essentially asking the court to do a de novo review of the facts in this case, which certainly the standard of review under the Kansas Judicial Act is not allowed. I do want to point out, and maybe I should explain before I point that out. In workers' compensation, what happens a lot is claimant says he's injured, and in this case, he went to his primary care physician, Dr. Reichenberger. He didn't even go to Spirit to report it initially. He went to his primary care doctor and said, hey, I woke up with a stiff neck. And that was his initial report, and that's important because I think that goes to actually what he related his symptoms to initially in his neck was, I slept wrong or I woke up with a stiff neck, never related it to his employment until subsequently. And then once he talked to his PCP some more, then he decided it was a work comp claim and he made a claim against Spirit. We generally, in that case, will send him out for a medical evaluation, whether it's with a local doctor or to an IME physician. We also, particularly under prevailing factor, which obviously wasn't a thing until 2011, when the law was changed. Before 2011, any aggravations or accelerations of pre-existing condition were compensable. You just had to show 1% aggravation, it was compensable. But 2011 changed that entirely and established this rule of prevailing factor, which I would submit to the court. And as Your Honor pointed out, you can't rely on an expert that doesn't know the past medical history at all. And that's what I would submit Dr. Dickerson occurred in this case.
Well, and to that point, it's my understanding that one of the biggest problems that the claimant has with Dr. Pratt's opinion is that Dr. Pratt didn't view a pre-December 2020 MRI, and so he couldn't opine on whether the claimant suffered a change in the physical structure of his body or had new physical findings. Is that correct? That he just reviewed other doctors' interpretation of the MRI, but didn't look at the MRI himself?
I don't think Dr. Pratt's, Dr. Pratt's deposition was not taken. His report comes into evidence because it's a neutral court-ordered IME, so no further foundation. So I don't know if he actually reviewed the films or just read the radiologist report, which is an interesting point because Dickerson, and I've taken Dickerson's deposition several times. He's always in favor of everything being work-related, not uncommon in this case that he made that conclusion. But the radiologist's interpretation of the MRI was all degenerative. And then he, what I call overread, which is essentially, I disagree with what the radiologist is saying, even though the radiologists look at hundreds of MRIs probably on a weekly basis. But a lot of surgeons will overread the MRI findings of the radiologist and say, no, I think there's more than just degenerative changes. But Dr. Pratt did have the MRI, either the radiologist report or the films. I'm not certain because we didn't take his deposition. But that's a red herring. I mean, I don't think it goes to really the weight of the evidence. And counsel's made this argument here today that Pratt didn't know what his job responsibilities were. Well, if you look at, and this is part of the regular hearing because it's attached to the regular hearing, I'd have to look up the record of appeal to see what it is. But Pratt's report's in evidence. And, page 1, claimant says he reports that he was lifting 65 to 70 pounds. Frames when he noted the aching in his shoulder arm on the right. Page it's reported a second time on page 2 of Pratt's report under vocational history. Counsel says, well, Pratt didn't ask him anything about what his job duties are. Well, it's in there twice. On page 2, he says he performed activities at Spirit since 2014. the time of his current complaints, he was working on parts or frames, lifting 75 pounds, blah, blah, blah. That's, again, a red herring just to try and place shade on Dr. Pratt's opinions. But he's the only neutral physician. I'm sure the court knows that, I started off my little conversation. Claimant says, I got injured at work. We send him to a doctor who says, no, this is not work-related. Then they hire their own expert, in this case, Dr. Marati. And Marati says it's all work-related. And then the court, because it's presented with competing medical opinions as to causation, sends him out to a neutral IME doctor, which in this case was Dr. Pratt, who did not relate causation for his neck condition to his work activities. But Pratt did obtain from the claimant, and he also had the benefit of reviewing these other IME reports from Marati and from Dr. Feverly, that gives a history of what the claimant has told these different physicians. And he can look at all those reports and make his own conclusions based on the history that he obtains from the claimant as well. And obviously, Pratt's basing his opinions not just on records review, it's also on physical exam, review of testing, history from the claimant and all that. And based on the presentation, obviously he didn't feel it was work-related. Dickerson, on contrast.
Well, and let me stop you right there too, because that's
Okay.
another argument that they're making is Dr. Pratt didn't say it's not work-related. He said, and it's my understanding they're saying this is a problem too because he's using the wrong standard. Pratt says, I can't state to a reasonable degree of medical certainty that the multi-level discogenic changes identified on the cervical imaging relate to his vocationally related activities in December 2020 until 21. And it's my understanding they're saying that's the wrong standard. He doesn't come out and say, no, it's not work-related. He's saying, I can't tell you within a reasonable degree of medical certainty that it is. Are we splitting hairs or is that important?
It's not important, it is splitting hairs. If you look at page 5 of Dr. Pratt's report under prevailing factor, he specifically says for the cervical thoracic involvement, pre-existing symptoms involvement documented in the record. So he's already pointing that this is an aggravation, acceleration, not that work is the prevailing factor. He goes on to say that the rest of it, but that's the way of saying, well, if I'm convinced it is work-related, then I would state within a reasonable degree of medical probability or certainty it is related. He's just reversing that around. It could have been better articulated, but yeah, I think it's the same. Anything else on that? I just got a couple of...
I just wanted your position on that argument.
All right, so the thing about Dickerson, as I pointed out in our briefs, is we show up, counsel takes his deposition. There's good reason to take his deposition. He was a surgeon, but he'd also already obtained an opinion from Dickerson that said he thought it was work-related. That's really the reason for Dickerson's deposition. But Dickerson didn't review any of these records. And these are significant. As we pointed out on our brief, it's not just, it's a minor problem.
Do you mind if I interrupt you? Would he have to, I mean, I know he hasn't reviewed the record, yes, valid. But he's the only one who cut into Mr. Crawford. I mean, he saw what was actually happening to the body. So shouldn't we give that great weight versus, he hasn't reviewed his other medical records? Surely if he's going to do surgery, he's going to be reviewing the person's patient history, right?
I get your point, but prevailing factor is a specific standard under work comp.
Right.
And you can't just rely on the subjective complaints of the claimant. I mean, claimants have a tendency to exaggerate their symptoms to begin with, and second of all, attribute everything to work versus, I had this prior injury and I'm fine now, even though they had permanent restrictions, which I'll get to. But prevailing factor is a specific statutory provision in the statute that they must overcome, and you can't do it with a Dickerson who doesn't know anything about his past medical.
And so even if he opened up and said, I see all this injury here, you may not have the prevailing factor there.
Yeah, I mean, I once asked a doctor, because I've been doing this too long, 40-some years, but, okay, in an MRI, can you tell me if when that happened? When did that
Exactly,
MRI happen?
that was my point.
And the doctor says, well, look at that scratch on that table. can you tell me when that occurred? No. And he had significant degenerative disc disease. It wasn't just a little bit, it was a lot. And in order to, and disc herniate, you could sneeze and herniate a disc. It doesn't have to be work-related. But he had signs and symptoms of radiculopathy, which is from a herniated disc. In his previous treatment, even his family doctor treated him for epidurals in a cervical spine and did an MRI. So this story that all the other prior injuries were minor, that's flawed too. He even had a previous settlement against Arby's that's in the record when he slipped and fell on the ice. So that's where I was headed, but
What about the argument that was made today that Dickerson, once he cut into him and saw the condition of the herniation of the disc, said he wouldn't be able to work with this significant of an injury, so obviously this was something new and different than what he had before?
well, I would submit to you so the timeline on this is they get a report saying it's work-related. We get a report that's saying that it's not work-related, or vice versa originally. And then it goes to a neutral, which the Pratt evaluation was in
July of 21.
July of 21. When's the first time he sees Weimer? Let me look. Because he saw a different doctor at the same group, had a different history. I'll have to dig it out because I'm not. What I was going to say is there's a lot of time in between he last worked and when Weimer saw him. I guess I don't have the portion of my medical summary that tells me when he saw Weimer. There was some time between the visits and, who knows when those discs herniated, if they truly were herniated. Again, the radiologist did not describe them as herniated discs. I think it's convenient for a surgeon that goes into a surgery and said, oh, there's herniation here, justifying the surgery, because they probably need to get it covered by his health insurance. You can't just do the type of surgery that he performed on subjective complaints. You really got to have a diagnostic findings. But my point is, these priors were significant. They weren't just minor, and I think a cumulative effect a little bit. We detail all of the priors over the years, including from his primary care physician, and then subsequently on page 3 of our Court of Appeals brief, he had previous neck problems in 2018, previous work comp claim in 2008, that's the one with Arby's where he received a settlement. Another funny point I find in this is, if you read Maradi's deposition, I went after him on this issue, is Maradi provided an evaluation in 2008 for the Arby's claim. He's the same expert they're now using on this claim. Maradi placed permanent restrictions on him in 2008. Did he honor those permanent restrictions? No. And on top of that, signed impairment for a upper back, neck, thoracic. Back in the day, it used to be cervical, thoracic. Now, under the 6th edition of the AMA guides, they've separated. But under the 4th, it used to be cervical, thoracic. But I questioned Maradi about, hey, you had a prior claim in 2008. You assigned permanent restrictions. Claimant says, oh, he was fine, didn't have any problems. Well, why was he assigned permanent restrictions? And in my book, permanent means permanent. He had bulging discs in 1999. He had the incident with the previous neck injury at Worlds of Fun. He had the previous episode while teaching his children to swim. I mean, he's got a chronic history of neck issues, is the truth and facts of the case. So I know my time's about up. One final irony in my mind is they want to use Dickerson's opinions to say causation is met, but when it came down to saying, they also want to argue he's incapable of working. Well, Dickerson actually did surgery on him, or at least with no restrictions. So it's, I think, inconsistent to say one thing and then say the other. So thank you. Any other questions? I know I went fast, and I apologize, but
Th-
nature of work comp.
Thank you.
Talk
We
fast.
appreciate it. We appreciate your 47 or 42 years.
88,
All right.
a little less than Jeff, so graduated from law school in 88.
Oh,
He's just
wonderful.
a kid, you know?
Mr. Cooper, you have your rebuttal time. We're going to move the clock to 3 minutes.
Thank you. I don't have a whole lot to say in rebuttal. I think the best evidence is the fact that this gentleman, even though he had some minor stuff before, he worked 6 years doing a heavy job without any problems until this injury. And then you get bids hiring doctors that nobody's ever heard. Everything's pre-existing condition. We sent him to
Can you
Dr.
do me
Ronnie
a
and
favor and speak, I'm sorry, to the standard of review at this point, rather than so
Right,
heavy into some of the
exactly,
facts?
yeah.
Give me the standard
And
review.
There's both sides of that, exactly. The standard review is what the evidence shows, and I think based on all the evidence, we believe the evidence shows that he did meet his burden of proof in proving that the work event was the prevailing factor in resulting in his injury, need for treatment, and impairment or disability. So we would request a finding in that regard. And unless you have any questions, that's all I have to say.
Well, what's your response, I mean, while you're up there, about the permanent restrictions that Marati imposed? It's my understanding they're relying on that. They mentioned it today as indication that
Well, I
there
think
was
Dr.
continuing
Brody
problems.
testified about restrictions or his recommendations considering the condition that he saw them at that time. But clearly, he worked a lot of different jobs after that without any significant problems. I don't think that's really relevant here. He applied for and was accepted, passed a test to work a very, very heavy job at Spirit and did that for 6 years until he's flipping them and has the pain and problems. And that's what, I think council made some suggestion that he just told him he slept wrong. It's pretty clear from Dr. Reichenberger's records that he's referring his problems to his work activities. So I think that's not quite correct. I'm sure you'll read the records, but look at Reichenberger's. This is his family doctor. He's not going there once a month or once every 6 months saying he's got neck pain or problems. There's no evidence after 2018 when he got a little bit of treatment up until 2020, 2021 was when next time, 3 years, when he saw Dr. Reichenberger. No evidence of any kind of neck problems that required any kind of treatment during that period of time. So I think that based on the totality of the evidence and the fact that Dr. Pratt didn't have the proper elements to review to arrive at the opinion that the board followed, warrants this being changed. Thank you.
Thank you, Mr. Cooper. All right, we will take this matter under advisement.